Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 60th lecture series. So, we have gathered here to discuss about a leading case which is prescribed for the Advocate on Record examination. And I request each one of you to recite the preamble with a commitment and sentiment, and that is our identity and that is our unity. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. I welcome you all to our lecture number 60. We are going to deal with minority view in state of Punjab versus Davinder Singh. This is a landmark judgment. The serial number is 83 in the revised leading case. And what is the purpose of giving a dissenting opinion? Because we all know, including the honorable judges, that majority holds the field. Then what is the purpose of giving a dissenting opinion? Because every judge's law is common. But application of law, application of constitutional provisions to the facts of the case differs from person to person. That is why honorable single judge holds certain things. Like in this case, honorable Punjab and Haryana High Court has held that the provision is unconstitutional. Now, honorable six judges has held that it is constitutional. Subclassification is permissible. But dissenting judgment expressed by her ladyship, Honorable Justice Bella M. Trivedi. Why dissenting judgment, dear friends? Ladyship, by quoting an important eminent jurist opinion on dissenting judgment, I would like to read that. Then I will tell you why the dissenting judgment is given. Though unanimity and consensus in the opinions expressed by the larger benches on the constitutional matters are desirable for the sake of certainty, because law is for certainty. Otherwise, high courts will get confused what is the law. Therefore, the constitution bench is constituted to settle the principle of law, to have more certainty on what is the issue. So, for the sake of certainty and strength of the law laid down, I, for one, believe that the dissent for well chosen reasons would be equally important. Dear friends, AOR aspirants, when there is a question that why do we give a dissenting opinion, the answer is this. Her ladyship has beautifully said, I, for one, believe that the dissent for well chosen reasons would be equally important for an effective adjudication in a democratic functioning of judiciary. Please note down these lines. Democratic functioning of judiciary, which would have potential to develop the law in future. So, her ladyship has expressed The majority on one side, 6 judges, has held that subclassification is permissible within SC community. Right. Her ladyship has expressed a dissenting opinion with reasons. It is equally important to as that of the majority view. For what reason the dissenting opinion is given? For democratic functioning of the judiciary. One, what he feels, what she feels, that has to be expressed. Though it may be a dissenting opinion, though it may be a minority view as of now, but for the evolution of law in future, the minority view may become a majority view in future. Therefore, when it is supported with good reasons, it is equivalent as that of the majority. So, democratic functioning of judiciary is one. Number two is it has a potential to develop the law in future. William O. Douglas, Justice of the US Supreme Court, a great dissenter who had written as many as 486 dissenting opinions. Her ladyship draws the support from the other judges, how they have dissented. The right to dissent is the only thing that makes life tolerable for a judge of an appellate court. It is the right of dissent, not the right or duty to conform, which gives. So, dissenting opinion, what does it gives? It gives dignity, worth, and individuality to man. Individuality to man. Oliver Wendell Holmes, Justice, another great dissenter, in his first dissent in the Supreme Court in Northern Securities Company versus United States, had stated, I am unable to agree with the judgment of the majority of the court. And although I think it is useless and undesirable as a rule to express dissent, I feel bound to do so in this case and to give me reasons for it. See how beautifully they have said. What is the use in giving the minority view? It is not going to bind on all the courts. At times it is not even cited before the court of law. It is useless, undesirable, but still I am trying to give. For what reasons? For the evolution of law, for the future, for the democratic functioning of the judiciary, that to establish his individuality with reasons in which he has a conviction. So therefore, dissenting opinion is given, dear friends. So how her ladyship has dissented from the honorable 6 learned judges? Let us see one by one. I am taking you to the relevant portion, dear friends. This is page number 336 at para 693. Dear friends, it is running to several pages, but as far as AOR examination is concerned, it is only 3 hours. You may dedicate maximum of half an hour to this. So therefore, note down all this, because this is a work of almost a week's time we have taken, and we have pointed out what is the important paragraphs. Note down, and it will be released in our YouTube also. Just don't mere watch the YouTube, dear friends. Please note down all those what we have said, so that will give you more idea. If you are just going to watch, you will remain as a spectator. If you are going to write, you will be the participant. Participation is most important. So let me read this, dear friends. The upshot of the above discussion may be summarized as under 693.1 paragraph. When the law was well settled, see how beautifully the dissenting opinion is given. When the law was settled by the Constitution bench in E.V. Chinnaya, after considering all the previous judgments, including Indra Sawhney, comprising of 9 judges, and after investing substantial judicial time and resources, the same should not have been doubted and referred to the larger bench by the 3 judges bench in Davinder Singh. And that too, without assigning any reasons, much less cogent reason for the disagreement, disregarding the well settled doctrine of precedent and doctrine of stare decisis. So, in the first paragraphs, see, they go step by step, dear friends. The honorable judges, when they express their opinion, they take us one by one. So, according to her ladyship, reference is itself bad in law, because just now we said how the matter reached the 7 judges. It was previously before 3 judges. 3 judges doubted the correctness of E.V. Chinnaya, comprising of 5 judges. Therefore, they have requested the Chief Justice of India to constitute appropriate bench. Why they should request the Chief Justice of India? Reason is, Chief Justice of India is the master of the roster. His lordship alone has the exclusive power on the administrative side to constitute bench. How many judges will sit and what they will decide, it is prerogative of the Chief Justice of India. Therefore, 3 honorable judges on the judicial side has requested the Chief Justice of India, who is the master of the roster, to constitute the appropriate bench. Then 5 judges was constituted. The 5 judges bench felt that it has to go before the 7 judges bench. But according to her ladyship says that referral is bad. Why referral is bad? Because E.V. Chinnaya was holding the field for several years, and you should not unsettle the settled position of law. The settled position is, whoever falls under the subcaste within the scheduled caste, they are all homogeneous. They are all stands on the same pedestal. So you cannot subclassify within the classification. That is impermissible as per E.V. Chinnaya case. And it was holding the field for several years. And if you are doubting the correctness, the 3 judges bench must tell in their reference how they are disagreeing. What is the reason for disagreeing with the constitution bench? That was not stated. No reasons was given. Unnecessarily they have referred. Therefore, the reference is itself bad. See, they are going to the root of the matter, dear friends. Root of the matter is attacked here. Referral is attacked. This is the first point. Second point is, and 2 doctrines as far as AOR aspirants are concerned, doctrine of precedent and doctrine of stare decisis. What does it mean? When there is a precedent case in E.V. Chinnaya case by 5 judges bench, it binds on all the courts. So it has a binding effect. So don't unsettle the settled position, and you are bound to follow. Just don't, for the sake of raising objection, don't raise it. It will unnecessarily affect the doctrine of precedent and stare decisis. So 3 principles are involved. One is doctrine of precedent and stare decisis, master of the roster, that is also there. Number 2, while giving a broad and generous construction to the constitutional provisions, I repeat, while giving a broad and generous construction to the constitutional provisions, the rule of plain meaning or literal interpretation, which is the primary rule, has to be kept in mind. So what they are talking about here? They are talking about interpretation of the constitutional provisions. So when there is a plain meaning, don't try to only see it as a plain meaning and give it a plain meaning only, literal meaning only. That is a primary rule for the interpretation of the constitutional provisions. So don't broaden it by forgetting the primary rule. Primary rule is give a plain meaning to it. Don't unnecessarily broaden it. That means you are violating the primary rule of interpretation. This is the second aspect. Third aspect is, The presidential list specifying scheduled cost under Article 341. Dear friends, Article 341, this is very important. Article 341 assumes finality and the publication of the notification, and the cost, races or tribes or groups within cost, races or tribes specified in the notification are deemed to be the scheduled cost in relation to that state or union territory, as the case may be, for the purposes of the constitution, and as such assumes special status of scheduled cost. What does it mean? Article 341 empowers the President of India to notify which subcost will fall under the scheduled cost. Once it is notified, they themselves becomes a privileged community. They are entitled for the reservation. So they assumes a special status as since they fall under scheduled cost. The next point is, it is only Parliament by law which can include in or exclude from the list of the scheduled cost. What does it mean, dear friends? It is only Parliament. That means state legislature has no power. So don't just read it just like that. It is only Parliament. You have to stop there. You have to talk to SEC judgment. Tell us. You are saying it is only Parliament means what? That means it excludes all the state legislatures. It is only Parliament by law which can include in or exclude from the list of scheduled cost specified in the notification notified under clause 1 any cost, race or tribe or part of or group within any cost, race or tribe. Such notification notified under clause 1 cannot be varied even by the President by issuing any subsequent notification. So it is by virtue of the notification, this is fifth point, it is by virtue of the notification of the President under Article 341 that the scheduled cost come into being, though the members of the scheduled cost are drawn from different caste, races or tribes, they attain special status of scheduled cost by virtue of presidential notification. The etymological and evolutionary history and the background of the nomenclature, scheduled cost, coupled with presidential orders published under Article 341 of the Constitution, make the scheduled cost a homogeneous clause. This is important. Make a homogeneous clause which cannot be tinkered with by the states. Dear friends, let me summarize these 3 points. According to her ladyship bringing out Article 341 clause 1, which empowers the President of India to notify any subcost under the scheduled cost. Therefore, they get a special status. Then her ladyship referring to Article 341 clause 2, which empowers the only Parliament to include any subcost under scheduled cost or exclude any subcost from the scheduled cost. So therefore, when the state of Punjab is giving a preference to Balmikis, it is like violating Article 341 clause 1 and 341 clause 2. So state has no power at all. So where is the question of giving preference? So therefore they are tinkering. They are violating. State of Punjab is violating Article 341 clause 1 and 341 clause 2. This is what the ladyship has held in this case. Now, further, the states have no legislative competence. Note down, dear friends. The states have no legislative competence to enact the law for providing reservation or giving preferential treatment to a particular cost caused by dividing, subdividing, subclassifying or regrouping the cost, races or tribes enumerated at the scheduled cost in the notification under 341. So when 341 clause 1 empowers the President to do so, Article 341 clause 2 of the Constitution of India empowers only the parliament to do so, it means what? States have no legislative competence. They don't have power at all. So, on what basis they give preference to Valmikis? That is the question. Seventh point, dear friends. Under the guise of providing reservation or under the pretext of taking affirmative action for the weaker of the weakest sections of the society, the state cannot vary the presidential list nor can tinker with 341 of the constitution. So, by saying that Valmikis are deprived class, they do not have due representation in the government jobs, you cannot discriminate according to her ladyship all the subcaste which falls within the scheduled caste, that they all constitute a homogeneous category. They are equally placed. So therefore there cannot be a preference to them. If you do so, it violates article 341 clause 1 and 341 clause 2, and state have no legislative competence at all. Now 9 judges bench. The next point, point number 8. The 9 judge bench in Indra Sawhney and the 5 judge bench in Jarnail Singh had not dealt with the issue of subclassification of the scheduled caste in the context of article 341, much less had dealt with the state's power to subclassify or subdivide or regroup the caste specified as scheduled caste under article 341 of the constitution, and therefore it could not be held that the law laid down in E.V. Chinnaya was not in consonance with Indra Sawhney or Jarnail Singh case. Reason is, dear friends, Indra Sawhney case, popularly known as Mandal Commission case, where they have dealt only with the reservation with respect to subclassification with respect to OBCs. So they have not dealt anything with the scheduled caste. Therefore, holding E.V. Chinnaya is not in consonance with Indra Sawhney case. It is not a correct approach. This is what her ladyship has held. Now, talking about article 142, point number 9. The power conferred upon the Supreme Court, under article 142 cannot be used to supplant the substantive law applicable to the case under consideration. Article 142 cannot be used to supplant the substantive law applicable to the case under consideration, even with the width of its amplitude. Article 142 cannot be used to build a new edifice where none existed earlier by ignoring express statutory provisions dealing with the subject, thereby to achieve something indirectly which cannot be achieved directly. The action of the state, though well intentioned and affirmative in nature, if violates the specific provision of the constitution, cannot be validated by the Supreme Court in exercise of its jurisdiction under article 142. Dear friends, this is very important. Article 142 of the Constitution of India. The Honorable Supreme Court is supreme in its power. One of the reasons is because of article 142 of the Constitution of India. The Supreme Court may pass any orders in order to do complete justice. We have heard about social justice, economic justice, political justice, timely justice, substantial justice. But what is complete justice? In order to achieve all those justice, it is complete justice. That is important, dear friends. So what is complete justice? Can anyone define complete justice? The answer is no. It depends upon the facts of the case. It depends upon how this Article 142 is applied to that particular case. That is most important in order to do complete justice. So such an extraordinary power, supreme power, vested with the Honorable Supreme Court. But in the dissenting opinion, Article 142 cannot be invoked. Why? Reason is, you cannot invoke to violate Article 341 clause 1 or 341 clause 2. When there is a specific provision which says only Parliament can do so, by 142 you cannot say that state can do so by giving preference. That is wrong. So this is not proper invocation of Article 142. So what you cannot do directly, meaning thereby the state of Punjab cannot give reservation or cannot give preference to Valmikis, because they don't have power under 341 clause 2. It is vested only with the Parliament. So what you cannot do directly, you cannot do it indirectly by applying this Article 142. That is wrong. Next point, 10th point. The affirmative action and legal frameworks, though both do aim at more equitable society, they must navigate complex legal principles to ensure fairness and constitutionality. What is fairness and constitutionality? See, the state of Punjab has come out with a yardstick that they made a survey and they found these Valmikis are not duly represented. Therefore, they should get a job. So let us give a preference, 50% preference. Well intentioned, that is good. But how do you execute it? It should qualify the test of constitutionality. It should qualify the test of fairness. Then only it will become constitutionally valid. So there may be a well intention. You may have a good intention. But how do you achieve that intention? Through legal way, through constitutional way, through fairness, you have to achieve it. Otherwise, it is not possible. This is what her ladyship has held. In view of the matter, I am of the opinion that the law laid down by the 5-judge bench in E.V. Chinnaya is the correct law and deserves to be confirmed. This is a minority opinion where her ladyship has held that E.V. Chinnaya case, constitution bench comprising of 5 judges, is valid. Now please note down, dear friends, what is the citation of E.V. Chinnaya case. E.V. Chinnaya versus State of Andhra Pradesh, 2005, Volume 1, SEC 394. 2005, Volume 1, SEC, page number 394. So this is what the opinion given by the minority view, dear friends. So now we have understood what is the majority view, what is the purpose of giving minority view. If minority view is supported with good reasons, it gives a democratic functioning of the judiciary and it will help for the evolution of law in future and individualism, and it gives a uniqueness in the judgment by giving reasons. So her ladyship supported with good reasons. So therefore, how do we see the majority view? We have to equally see the minority view also. Ultimately, we are all lawyers and we may appear on one day for the state of Punjab, and on another day we may appear for the person who are deprived of the reservation. So we have to know both the views. Therefore, whoever engages you, you will argue on their behalf. Thank you so much, dear friends, for your patience hearing. I am truly blessed and privileged. Thank you. Thank you. Join us for a group photo, dear friends.